Welcome to Real Estate Focus. I'm Kelvin Law. Our topic is real estate laws. With me here is Russell Chin. He is the president of Chin Law Firm in Quincy. Chin Law Firm specializes in real estate laws, divorce, and immigrations. Welcome.
Thank you, Calvin. Nice to be here.
Glad you can join us today. Let's talk about what a normal real estate transaction is. In a normal real estate transaction, the buyer and the sellers have an accepted offer, and the buyers and the sellers agree upon about the home inspections. So therefore, before entering into signing the purchase and sale, they must retain a real estate attorney. And the real estate attorney will represent the buyer and the seller through the transactional process. So therefore, that's when a real estate attorney like Russell Chin will enter the picture. So having said that, after the buyer or the seller have retained your real estate services or legal services, what are your duties?
Okay, so the duties of a seller's attorney is quite different from the duties of a buyer's attorney. And if I'm the seller's attorney, what I want to make sure is that the seller is able to give good title to the buyer. I first start out by drafting a purchase and sale agreement because that's customarily the seller's attorney's obligation. I draft a purchase and sale agreement after speaking with my client to make sure that what we're agreeing to sell is all included in there, and what we're not going to sell has been specifically excluded. I make sure that all the terms are fair and reasonable, and that we send it off to the buyer's attorney. If I'm the buyer's attorney, my focus is entirely different. I'm trying to make sure that the buyer is protected throughout the transaction, and there are many more steps for the buyer to follow. The buyer's money is at risk, his deposit is at risk. I want to make sure he has enough time to apply for a mortgage, get a mortgage commitment letter, make sure that his deposit is protected throughout that time, make sure that he has enough time to do that, and make sure that the title is good that he's going to get.
Right. And this is after they sign the purchase and sale, then basically, you will follow through the whole process and to the closing.
Yes, certain dates are put into the purchase and sale agreement that are trigger dates. One would be the date that
the commitment date.
The commitment date,
Right.
And that's paragraph 26 of most purchase and sale agreements. That's a very, very important date for the buyer to remember.
Right.
If he goes beyond that date and he hasn't gotten a commitment letter, his attorney must notify the seller side and get an extension to that date. Otherwise, he would be forced to buy the property regardless of whether he gets the loan, or in the alternative, forfeit his deposit.
Right. So that's the most important, one of the most
I
important
think so.
days on the purchase and sale. Yes.
Yes.
Yeah. And for most sellers and for all the buyers, especially in the buying process, why do they need an attorney to represent them during the transaction process?
Well, typically for most buyers and sellers, they're dealing with a large amount of money. Most buyers are spending 6 figures, if not 7 figures, on a property. It's not something that they do every day. And so there's a big investment involved. There are also going to be closing costs and bank fees involved, and it's a big deal. This is their home. So they want to make sure that they're getting adequate representation, and they're going to be signing an awful lot of legal documents that are going, the purchase and sale and the offer are just the beginning. There are going to be many, many documents, and they're filled with legal language and technical language, and I think it's if you're spending that kind of money, one would want to have adequate representation in doing that.
Right, and especially nowadays where the buying process is very complicated, and there are a lot of term and conditions and negotiations involved as well. So it is I think is a smart investment or a little investment to hire an attorney to represent you throughout the home buying process, especially, or selling process a little bit easier, if you will.
I think the selling process is a little bit easier for the seller. The seller needs to make sure that, again, that they've cleared up or able to clear up any liens on the title. So they want to make sure that there are no problems. And you hire a seller's attorney to make sure that the title is good. They can do a quick search, or they can do a very thorough search and make sure that the title is good. They may check your title insurance policy if the seller has one. They're going to coordinate with the mortgage that the seller has to make sure that the payoff is correct and that a discharge will be coming in time for the closing. And they're going to make sure that all the taxes and the liens have been resolved before the closing date comes, because by then you've got to be able to perform under the contract. You've got to be there, you've got to be able to give the deed. The seller's attorney also prepares the deed for the seller.
Okay, great. Yeah. So, most consumers, they're not sure where to find an attorney, especially a good attorney. So, where can they find an attorney other than referrals? I mean, can they look online? What resources that they can use to find an attorney?
Sure. We get asked that question an awful lot, and there are some very good attorneys in Massachusetts. Of course, there are some who aren't. And I think one would want to look for an experienced attorney who has done many of these types of transactions, and it isn't his or her first time around, and that the learning curve is steep. Oftentimes, I tell people to contact the Mass Bar Association. There is a real estate section, real estate lawyers section, and real estate professional lawyers typically will become members of that particular section, and they keep a list of the real estate attorneys there.
And in terms of legal services and finding the right attorney, what are the biggest complaints about an attorney that the seller or the buyers has retained?
I think the biggest complaint about attorneys in general is that the attorneys don't respond to phone calls as frequently as the client would like. Mm-hmm. They find that attorneys are sometimes too busy, handling too many cases, aren't paying enough attention in their mind, and aren't returning phone calls promptly.
And so nowadays, I mean, including as a realtor, as a loan officer, as an attorney, responsiveness and also communications are very important to the clients, especially in a deadline setting.
Highly critical,
mm-hmm.
Calvin. And what we like to do in the office is we like to make sure that a real estate paralegal has been assigned to the case and has all of the information, soup to nuts, in the file. The attorney is also involved in the case. We have the translators who have first-hand knowledge of the case and can do the dialogue with the client as necessary. And one other thing I forgot to mention about choosing an attorney, oftentimes the brokers will know a good attorney that they have worked with who they can recommend.
Mm-hmm. Right, and that's one of the good resources that the buyer or the seller can go with. Before the closing, most sellers and buyers and also attorneys will get the HUD. So what is a HUD?
A HUD is a euphemism for a settlement statement. And a HUD settlement statement is often referred to as the HUD. What it is a document, usually 3 to 4 pages, that contains the entire financial transaction on it, so that one can see directly from those pages exactly what has been paid, what's going to be paid, what checks are being issued, and the reasons for the checks being paid. So that, and then they're signed by the buyer, the mm-hmm. seller, and the settlement agent, who is usually the attorney for the bank. Those documents are signed by everybody and then circulated. And those are important to keep and to provide to an accountant at the end of the year for tax purposes.
Mm-hmm. And the fees will be on the HUD, and I'm talking about all the fees for the seller and for the buyer. So left-hand side belong to the buyer, right-hand side belong to the seller on the HUD. So anyway, when it comes to title, what can make a title to become defect?
Right. Buyers and sellers are going to hear the word title an awful lot. And what title refers to is the ownership of the land. And in Massachusetts, as in most any other state, the title moves from owner to owner. The land stays where it is, but the ownership of that land goes from one person to the next owner to the next owner. So what the seller is conveying or giving is a deed that means that they own the property. How can that be affected? That can be affected by liens on the property. A buyer wants to make sure that they're getting what they call good title, meaning that it's good, it's clear, it's marketable, and they could turn around and sell it to somebody else without a problem. Well, the question being, what could possibly affect that? Many things could. For example, taxes. If the taxes are not paid, the city places a lien on the house or on the property called a tax taking. And until that tax bill is paid, that tax taking stays there as notice that there's an amount owed. A mortgage is another defect on the title. It's a lien on the property that has to be paid in order to make the title clear. An attachment, if a person, let's say your seller had been sued by a credit card company or by a creditor, and they attach the property, they put a lien on the property. That lien has to be cleared up before the seller can give good title to the buyer. So those are a few different examples of the kinds of things that could be problematic.
Now, in a lot of instances where a seller refinance, and after the refinance, then the lender or the attorney forgot to record the discharge with the court. And so when it comes to selling the property, especially where the buyer's lender found out that there used to be a mortgage, but that mortgage was not recorded. So they need time to go back and basically track that discharge, and the delay of the closing would affect it. So something like this, I mean, is important to pay attention, right? Especially as an attorney.
Very important to pay attention. As I mentioned before, as one of the seller's attorney's jobs is to make sure that the title is clear, so that if they found that there was an unrecorded discharge of mortgage, that attorney would have to take steps to try to clear that mortgage. And that bank may or may not still be in existence. The bank may have assigned the mortgage to another entity, and then the attorney is trying to track who then holds the paper that would be able to give that discharge of mortgage. Oftentimes what we do is we look to see whether the owner has purchased title insurance. And if the owner purchased title insurance at the time that the owner bought the property, the title insurance company will often step in and provide a letter of indemnification so that the buyer can be assured that even though they go forward and this discharge is still hasn't been recorded yet, that the title insurance company is going to step forward and make sure that the discharge is located and recorded properly.
Oh, good to know. And at the closing, most buyers, especially buying, an attorney asking the buyer will ask the buyer to purchase a homestead. So a homestead usually go for 150, is that right, for the whole thing? Yeah. And in this case, most attorneys will encourage the buyer to purchase a homestead. So what is a homestead, by the way?
Sure. A homestead is a document. It's called a declaration of homestead. And it is typically a two-page document that gets recorded at the Registry of Deeds along with the deed and perhaps a mortgage. And what it does is it provides protection for the homeowner from creditors who might want to attach the property. By statute, we already have a certain amount of equity that is protected. But by filing and recording a homestead, we get up to $500,000 in equity protected from creditors. It is not effective as to the mortgage that one would get when they're buying the property, but as for creditors coming after that, if there's equity available for the first $500,000, it is protected from other creditors. The recording fee is about $35, I believe, $30. And people oftentimes will charge between $70 and $100. As an accommodation to our buyers, we prepare that homestead for free, and they only pay the recording fee.
Right. Okay. So that is something that the buyers must have, especially first-time home buyer.
It's we strongly recommend it, and it's a one-time charge, and it's very little money to pay for a lot of insurance from being sued.
And it is one of the biggest investment or asset that
Correct.
a person might want to look into. Now, when it comes to purchase and sale, now a purchase and sale consists of a lot of legal languages, if you will. And if you can share, what are the most important items that are on the purchase and sale that both the buyer and the seller should be aware of before signing?
Well,
just a few, if you will.
A few, sure. The buyer and seller want to make sure that, obviously, in paragraph 1, their names are spelled correctly.
That's
because
correct.
For the buyer, particularly, all of the mortgage documents and the loan documents are going to have the spelling based most likely on the P&S agreement. And besides, by the way, we call it P&S for short, purchase and sale, P&S, P&S. The second paragraph, as well as important, because that contains the description of everything that's going to be included in the sale. So we want to make particular attention that if there's a refrigerator, a washer, dryer, it's specifically included. If there are drapes or curtains, window
personal
treatments,
belongings,
those all need to be incorporated in there. Paragraph 7 would be the purchase price, and of course you want to make sure the purchase price and the deposit amounts are correct. And in paragraph 8, of course, the time for performance. You want to make sure that as a buyer you're going to be able to close on that date, and as a seller you want to make sure that you can get everything ready and move out by that date. We talked about paragraph 26, which is the mortgage contingency date, and that's a critical time as well.
And any, especially when it comes to rental properties, any, rent adjustment, any security deposits, any preparations need to be done. It's going to be, part of the purchase and sale. Yeah.
The standard purchase and sale agreement does a pretty good job of covering 90% of the issues that a buyer and seller might commonly encounter. It's up to your buyer and seller attorneys to make sure that the balance of the purchase and sale agreement has been customized for your specific transaction, so that everything that is special to your purchase and sale is in that agreement. And we often do that with things like riders to purchase and sale agreements.
Yeah. So the next question is, what is a rider? Because a lot of times, the seller's attorney and the buyer's attorney will draft a rider to protect the seller and the buyer, and so the riders is going to be a rider A and rider B as part of the purchase and sale. So what is included in the rider, if you will?
Sure.
Yeah.
What's included in the rider are additional terms and conditions to the purchase and sale agreement that either are going to favor a buyer or favor a seller, depending on which attorney drafted it. And those become negotiable. There is a trend that I have seen over the past 12 months or so where the rider is becoming more of a balanced document. What I mean by that is that the attorney who has drafted the rider, frequently the seller's attorney, because as I mentioned earlier, seller's attorney has the customary responsibility for doing the first draft of the purchase and sale agreement, that rider is now becoming more evenly balanced, and so that there's less negotiation that is necessary. Both sides have sort of, in an unspoken sort of rule, decided that it doesn't make sense to keep drafting these one-sided riders, rider A one-sided for the seller, and then rider B one-sided for the buyer, and then knocking heads when really the buyer and seller just want to get this thing done. They want to buy and they want to sell. So why should the attorneys get involved in trying to negotiate and
cause more problems,
cost more money, and so forth. So I'm glad to see that there is a trend in real estate among attorneys where the rider is now much more balanced and it requires less negotiation.
And at the end of the day, I mean, all involved parties have to work as a team.
Correct.
You know, even though there are negotiations involved, you know, there are, you know, favorable terms and conditions that, you know, the sellers must have and also the buyers must have. But, you know, looking at the big picture at the end of the day, I mean, everyone has to work as a team to complete the transaction seamlessly, if you will,
Yep.
and in a professional manner.
It's a good point, because if you choose the wrong attorney, let's say you choose an inexperienced attorney, he may not know whether a term or condition is customary or fair and reasonable. He wouldn't have the experience to know that. He also may not have the experience to put in language that is necessary for your transaction. You may find a litigation attorney who wants to negotiate every term because that's what he's used to doing, but you don't necessarily want a litigation lawyer, which is the lawyer who goes to court and you know, does lawsuits against other people,
Right.
handles lawsuits and litigation. You don't necessarily want that kind of attorney for a transaction like this.
Right.
You want someone who
More
knows,
specialized.
yeah, more
Yeah.
specialized and knows the lay of the land, knows what is customary, what is reasonable, you know, what the trends are in real estate.
Right. And what their intentions are, I mean, when it comes to protecting the seller and the buyer.
Of course.
So, yeah. And you had touched on, you know, in terms of finding an attorney. So, other than, you know, experience on closing of a lot of transactions, what type of questions, just to share a few, that a buyer or a seller should ask an attorney before retaining one?
I would ask the attorney how many transactions of a similar nature they have done, how well do they know that neighborhood or that city, what kind of issues do they think the seller or the buyer should be aware of. You can do a little bit of an interview of that attorney and get a sense as to whether they are answering your questions, you know, directly, or whether they're not quite sure of how to answer them.
Right. And I know that for most people, I mean, the fee is very important, but I believe the experience and also the professional manner of an attorney is very important as well. Because at the end of the day, again, you know, everyone has to work as a team to move the process forward and to close the transaction. And as far as like deeds wise, I mean, there are 3 different types of deed in Massachusetts. One is called warranty, the other one is called quitclaim deed, and then the last one is fiduciary deeds. So if you will, please explain briefly to the viewers what is a warranty deed.
Sure. The warranty deed is not very commonly used in Massachusetts, but it is the best deed that a buyer can receive. The warranty deed from the seller states that the seller is guaranteeing that any issues from all of the previous owners from the beginning of time up to that seller are going to be resolved or will be clear. There are no issues at all going back for the entire history. That's called a warranty deed. The quitclaim deed is the common, customary deed that you see in Massachusetts. And the quitclaim deed from a seller is his representation, his guarantee to you that while he owned the property, there were no issues that would affect the title. The fiduciary deed is a third type of deed, and that is not very frequently seen. That is the least amount of protection that a buyer could receive. And it's basically that whatever title the fiduciary has, or whatever rights the fiduciary received while he was a fiduciary, that is what he is then transferring to the buyer.
Right.
Only those rights, nothing before he became a fiduciary.
And staying on a D question, from a buyer perspective, what is the best way for buyers to, you know, protect themselves from any unknown title defects, potentially maybe discovery subsequent to the sale transaction?
I think that the best way to protect oneself from title defects would be to purchase the title insurance. The lenders require the buyers to protect the lenders, so you have to buy a lender's policy, but you can also simultaneously buy a buyer's policy. and that protects the buyer from situations that might not be obvious from the title examination or from any potential defects that arise throughout the chain of title prior in time.
Right. So there are different titles in Massachusetts, and one of the common one is joint tenancy with the right of survivorship. The other one is tenancy by the entirety. The last one is tenancy in common. Can you explain to to us what each stands for?
Sure. Well, take the second one first.
Mm-hmm.
The tenancy by the entirety, attorneys often refer to this as T by E. Tenancy by the entirety is one way to hold title, but you have to be married.
Mm-hmm.
It's only available to a husband and wife, and if people hold it as T by E, they are given certain additional statutory rights if a creditor were to go against the property.
Mm-hmm.
Meaning that if the creditor were to sue the husband, the wife would still have the right to remain in the house.
Mm-hmm.
That's important because if the creditor were to try to sell the house, the wife would still have the right to be there, and it would be very difficult for that creditor to sell that house with the wife still living there.
Mm-hmm.
The other one that you mentioned first was the joint tenancy. This can be held two different ways: joint tenancy alone or joint tenancy with right of survivorship. Joint tenancy means that both sides own 100%. So that if one person were to pass away, then the other person would own 100% of the property.
Mm-hmm.
If it's joint tenancy with right of survivorship, that's the way it works. If it's just joint tenants, then if one person dies, his 50% share would go to his heirs, his children, his mother and father, whoever happens to survive him.
Mm-hmm.
The tenants in common is often used to hold property by people who aren't related or aren't married. They might be friends, they might be relatives,
Boyfriend, girlfriend?
boyfriend,
Yeah.
girlfriend, fiance, and so forth. And you can divide up the proportionate share in tenancy in common. One person could hold 99% and the other 1%, could be 50-50, or any combination leading up to 100%.
Mm-hmm. And I think nowadays, especially when it comes to selling property, a lot of people might run into a different kind of sale. It's called estate planning. What is estate planning?
Estate planning is a way for people to prepare for the day when they die. And it is a way to protect one's assets, to plan for the future. It typically involves the preparation of a will. It may involve the preparation of a trust. In fact, I'm conducting an estate planning seminar on March 2nd that will be open to the public, and it would be held at 1200 Hancock Street on the 3rd floor. And when I conduct this estate plan, I'm going to be introducing these concepts to the people and showing them how the use of trusts and the use of insurance products can save dramatic amounts of tax when a person passes away. We'll be going into probate and what that means and how to avoid probate. We'll be going into how to protect your assets from creditors by putting things into a trust, reducing your estate, which has then become taxable, and different ways that you can control, call it controlling from the grave. You can control from the grave how you want your assets distributed.
Great, fantastic. So, yeah, I want to thank you for sharing.
Very
and,
welcome, Cal. It's a pleasure to be here.
Thank you for being here. Having a real estate attorney to represent you during the home buying or home selling process is paramount. And also, it will give you a peace of mind, along with protecting any unexpected litigations after you sold your home or after you own your home. I want to thank you for watching. Work.
What?